Welcome back. My voice is rough today, but the facts are clear enough. What you are looking at on screen is not confidence or intelligence. It is a self-represented tenant walking into court armed with internet slogans, instead of legal arguments. The sign, the posture, the attitude. All of it tells you exactly how this is going to end. This case is about an eviction, and the outcome is already written before the hearing even starts.
Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right, Mr. Davis or Ms. Davis? Okay,
yeah, I'm the beneficiary of Dwayne Davis right here. The beneficiary.
What is a
beneficiary? There is a pattern you see over and over with these defendants. They rely on wordplay instead of law and identity theories instead of evidence. They believe labels and titles somehow override procedure. Courts do not operate on vibes or clever phrasing. Judges care about filings, service, and compliance. None of that is present here.
Excuse me, are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
Do you reside in that property?
The beneficiary, yes.
The person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
All right, okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular case.
I just did. I just told you I'm the beneficiary.
Your Honor,
of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Before we proceed with this matter, can I ask the director, the beneficiary? I'm talking to the plaintiff, sir.
This fixation on so-called legal grammar does not protect anyone. It does the opposite. It delays nothing, convinces no one, and routinely leads to worse outcomes. People who follow this approach tend to stack losses on top of losses. Evictions, judgments, and sometimes criminal exposure. This case is no exception.
My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that is required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against.
I have a birth certificate right here.
Against the law. Two, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was never notarized.
Signed with Dwayne Davis Jr., as well as the proof of service.
The paperwork issue is straightforward. Proof of service exists. That is what matters. Notarization is not the magic shield the tenant thinks it is, and even if it were required, it would not replace service. Any attorney with basic housing law experience would recognize that immediately.
Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say 900.
When's the last time you paid rent?
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back.
I don't know. I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it.
Here is where things potentially turn serious. During the pandemic, rental assistance funds were distributed in different ways. Sometimes money went directly to landlords. Other times it went to tenants with the obligation to forward it. If funds were issued and the landlord never received them, the question becomes simple. Where did the money go? If it was kept, that is not a technicality. That can cross into criminal territory.
That is not our burden.
Okay.
It's his burden.
But that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage. He's the renter. It is his responsibility to have the money paid, or to whoever's paying on his behalf, that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
The tenant also seems confused about who owes him anything in this courtroom. The opposing attorney does not work for the tenant. He represents the property owner. There is no duty to educate, assist, or entertain arguments that have no legal basis. His role is to move the eviction forward, and that is exactly what he is doing.
Your Honor, I am not writing. I'm not
Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay.
Choosing not to respond or participate is one of the fastest ways to lose a civil case. When a party fails to defend, the court does not pause out of sympathy. The process continues. Default judgments exist for a reason. And this hearing shows how easily they happen when someone refuses to engage with reality.
Okay, we are entering, the court has not received the call or answer from Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded asking for my default judgment. We can submit it to the court before the end of the day, along with a full ledger.
Default judgment granted.
Thank you, Judge.
Please submit the paperwork. Call it, you're free to leave. Well, nobody identified themselves, so calling the next case.
By the end, there is no dramatic reversal, no rescue, no surprise win. The court issues the judgment, the case concludes, and everyone moves on. The tenant sits there trying to process what just happened, but the system has already done its job. If you found this breakdown useful, stay tuned for more courtroom analysis. This is Judge Talks.